Hi everyone, welcome back to the channel. Thank you for watching, and of course, news like this is going to be suppressed, so please, if you have a second or two while you're listening to me yak on, hit those buttons down below, interact with the video. It tells the machine that more people need to see this, and we're not going to get any help from YouTube and the powers that be on this one. So today we're going to be talking about an important case that actually is a little bit deeper than I think it initially presents, and I'll describe that in a few minutes, but this topic arrives at just the right time, because if you were to look out that window right there, you would see that it is basically uninhabitable for filming outside because the ecological problems of Canada have now found themselves down to southeastern Ohio. What we're talking about is this case, the United States versus Bullock, which is a felon in possession case. Now, I'm going to stop you right there because there's a certain amount of people, a certain proportion of people that are watching this video, and their initial knee-jerk reaction is, yeah, dangerous people shouldn't have access to deadly weapons. Stop. Uniform application of logic is what we strive for here, and I know that many of you who are watching this video already know what I'm going to say. If somebody has been deemed to be unsuitable for access to deadly weapons through due process of law, in this case, we're talking about firearms, but you can extract the firearm out of the equation and insert knife, hammer, car, baseball bat, hands and feet, which are the predominant form of violent crime perpetration in the United States. You're going to start chopping off people's hands and feet. You're going to create a whole bunch of cripples out there because you don't want them to have access to deadly weapons. If someone is incapable of exercising all of their constitutionally protected rights, as in they are deemed a large enough threat to society that they should not have the right to vote and should not have the capacity to defend themselves, well, then they shouldn't be on the street. Plain and simple. If someone is capable of being a productive member of society, then they should enjoy the full breadth of their constitutionally protected, God-given, inalienable rights, regardless of whatever crimes they've committed in the past. My phone, not yours. I'm sorry. If you would like to support the channel, then you can find our affiliates page listed in the description box down below, where you can find great deals on items that I use and stand behind. And if you were going to buy that stuff anyway, then using my code or affiliate link gives a kickback back to the channel. Thank you very much. So some real quick lay of the land type stuff, details about United States versus Bullock. So to get kind of the origins of this whole thing, we have to go all the way back to 1992, involving a Jesse Bullock, who is in his early 30s at that time. And Mr. Bullock does a boo-boo, if you will. He committed an aggravated assault. And for those of you who don't speak legalese, that means that he assaulted somebody with a weapon. He went down for that crime and he was convicted of a felony. Now, all of you who have purchased a firearm before know that on your 4473, one of the questions is, have you ever been convicted of a crime, or have you ever been indicted for a crime that is over a year in prison, or, whatever. Those questions on the 4473. If you were convicted of a felony, that is a lifetime prohibition on possession of firearms and ammunition. There are ways to have that removed from your record, but it's exceptionally expensive, and oftentimes it does not take, particularly if we're talking about violent crimes. Fast forward to 2018, and a now 57-year-old Mr. Bullock at the time was indicted for knowingly possessing a firearm, which carries a penalty of up to 15 years in prison. Some time passed, didn't really hear anything about that whole thing. And then in October of 2019, a superseding indictment was filed that brought it to 10 years. But what we find out is, I can't put it any other way than this, but his wife called the cops on him. They had some kind of disagreement, and she basically said, hey, he's got guns, he's not supposed to have guns, et cetera, et cetera, et cetera, right? So, gentlemen out there, act accordingly. March of 2020 comes around, his arraignment. Well, we all know what happened in 2020, right? And how we spent that time. Not a whole lot that the guy could do. Are you a felon, and are you in possession of a firearm? If yes, then yes. If no, then no. Well, I suppose the way that our justice system works today, then no, maybe. Regardless, fast forward to the 28th of June, under a judge, Carlton W. Reeves, district judge. I'm going to read you some excerpts. Gun rights advocates used to say that the Second Amendment was treated as a second-class right. That all changed in 2008. That year, the Supreme Court decided that the Second Amendment guarantees individuals the right to keep and bear arms in their home for self-defense. Heller. Then goes on to McDonald, cites Scalia several times, and then goes to Bruin. The federal felon in possession ban was enacted in 1938, not 1791 or 1868, the years the Second and 14th Amendments were ratified. The government's brief in this case does not identify a well-established and representative historical analog from either era supporting the categorical disarmament of tens of millions of Americans who seek to keep and bear arms in their home for self-defense. Page 4. It's 77 pages. American history might support state-level felon disarmament laws. That at least would align with the principles of federalism. It might support disarmament of persons adjudicated to be dangerous, as Justice Barrett found when she sat on the Seventh Circuit. And it likely does support disarmament of persons convicted of death-eligible offenses. The power to take someone's life necessarily includes the lesser power to disarm them. The government's argument for permanently disarming Mr. Bullock, however, rests upon the mirage of dicta buttressed by a cloud of law review articles that do not support disarming him. In Bruin, the state of New York presented 700 years of history to try to defend its early 1900s era gun licensing law. That was not enough. Bruin requires no less skepticism here, where the challenged law is even younger. The government basically said, here is the precedent that we have used up to this point to say this guy can't possess guns. The judge says this: after reviewing the briefs and Bruin, the court grew concerned. Judges are not historians. We were not trained as historians. We practice law, not history. And we do not have historians on staff. Yet the standard articulated in Bruin expects us to play historian in the name of constitutional adjudication. In this case, no historian has expressed an opinion regarding the history of felon disarmament. Neither the government nor Mr. Bullock submitted an expert report on the historical analogs to modern felon in possession laws, if any. No interested organization or members of the Academy filed any amicus brief. All we have are appellate judges' interpretations of the historical record. And some of those interpretations are credibly accused by actual historians as being a cherry-picked ideological fantasy. After this review, this court did not want to be guilty of itself cherry-picking history. It asked the parties whether it should appoint a professional historian to serve as an independent expert in this matter. The parties answered no. Mr. Bullock observed that the burden to prove history and tradition is on the government, not the defendant. Defines legal standard before 2008, Heller, McDonald, Judge Barrett, Bruin. The judge says, y'all didn't bring any historians in here. I'm not a historian and neither are you. So unless you bring me in here a historian that can point to me a specific instance from the historical record of the time period that we're talking about that is an analog for felon in possession laws, felon in possession prohibition laws, then it ain't gonna fly. Also, farther down in the 70-page region, it starts talking about how this applies across the board. It says that currently the Bruin and Heller decision are Second Amendment law cases, but they need to move from there to other things like right to speedy trial, habeas corpus, voting rights, etc., 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 because there needs to be a uniform application of logic across the board, not just as it pertains to the Second Amendment. Well, let's bring it back home to Second Amendment related issues. If we're saying that this is a broad enough mind set that it can move over to those areas, then this should apply across the board to firearms regulations. Well, where does felon in possession live in the United States Code? It lives in 922. What else lives under 922? Well, a whole lot of things that you as an American citizen have been living under for quite some time. We're talking about importation bans, 922R, that artificially increased the price of things that you have to pay for because some politician somewhere thought that that was going to be. I implore you, if you have a little bit of time, to browse through this this decision so that you're well versed on it. I would love to know what you guys think about it, because I think that the way that he's got this laid out is going to win at the appellant level. And if the government is dumb enough to appeal it to the Supreme Court of the United States, oh my goodness gracious, they're going to have an absolute field day with this. So thank you all for watching. I hope that you enjoyed this video, and we'll see you on another video here at the VSO Gun Channel, provided that we don't get censored.